Could you be a little more explicit on the Damien Eccles case? Do you have specifically a problem with the AG's office's the way it's handled it, or question? Your response was kind of general.
You know, I'm not privy to everything that the Attorney General sees when they make the decisions on what to do in that case. So it's easy to second guess another lawyer for their litigation decisions when you're not looking at what they're looking at. But from the point of view of someone looking at the situation from the outside, it has seemed like there were times when there was evidence available that would have shed light on the case, and the Attorney General has opposed allowing that evidence to be heard before a court until the court insisted that the evidence be provided. And then, you know, they've complied with the court orders like they should. But I question sometimes whether that opposition needs to be there in the first place. When you've got new DNA evidence as an issue in a death penalty case, I would think that everyone in the universe should want to see that evidence come to light, should want to make certain that the decision that's being made in that most dire of circumstances is the right decision. And I don't really understand why you would ever want to put up any resistance to having that type of physical evidence known.
So you're referring to particular decisions that the AG's position?
Well,
AG's office is taken under McDaniel, or are you just talking general?
Well, McDaniel mentioned how they provided more articles of DNA evidence even than the defense had asked for. But, you know, they had to be court ordered to do that. And I don't think it should always take a court order to get someone who represents the people to say, you know what, let's get the evidence out there for the court to view and decide on.
You talk about representing the people, but the Attorney General also represents the state. So where does that balance fall?
Well, the people are the state. The true interest of the state is the interest of the people. The state officials that the attorney has to represent in the course of his job, that's certainly his duty to do that. But I think sometimes that duty comes down to advising those state officials to do what is in the interest of the people. And I think sometimes it's too easy to focus on it from a point of view of as if you were a private lawyer representing a private citizen for what was in the interest of that private citizen. And sometimes you have to take a step back and say, what is the real interest of the Arkansas state legislature or the Arkansas Gas and Oil Commission in this matter? And their real interest is to do what is in the interest of the people of Arkansas. And I think sometimes it's appropriate to advise them to do that. I don't mean that you don't zealously represent your client in court. There are many issues on which reasonable minds could differ, and boards and commissions, legislatures, other state agencies are making decisions that are appropriate, are within their jurisdiction, are things that they have a right to make, and things that people in the state could differ all day long as to what's in the best interest of the people. And I think it's entirely right and appropriate for the Attorney General's office to represent them as any lawyer would and to back them up on that. There are also times when it's not such a judgment call. There are times when a state agency or other organ or official of the state does something which is simply unconstitutional. And I think the Attorney General's office needs to handle the situation where someone acts outside of their authority differently than the situation where someone simply does something that, as a judgment call, the Attorney General personally wouldn't do. If someone acting within their authority does something that, you know, as a judgment call you wouldn't do, then your duty is to bite your lip and represent your client. But if someone who you represent is acting outside of their authority, essentially is acting in contravention to the law, you have the responsibility to make them aware of that and to deal with that on that basis.
So, do you think this debate helped or hindered your campaign?
Oh, Oh, I think it helped very much, and I appreciate AETN and AARP for letting us do this. I think this is something that's so essential, which is getting the candidates in front of the people so that the people can see what the differences are in the candidates' positions and make a decision for themselves. I think, unfortunately, a lot of what goes into politics in America today is who can afford the best television ads, and I think this evens that out somewhat, because it's not about who can afford to get out there in front of the people. It's about the people helping themselves get the information that they need, because AETN is also the state of Arkansas. AETN belongs to the people of Arkansas, and I think it's doing an excellent job of providing the people of Arkansas with what is needed in terms of media and education in this state, and they deserve our thanks and praise.
You mentioned stop having prison be a sentence for nonviolent offenders.
Well,
Would you be in favor of something like a Wiggins those for more?
no, and I believe I said that first and second time nonviolent offenders should not be taking up space in prison, and there are already procedures for that. There's probation, there is community service. I think we need more of that. I think we need sentences that reflect from the beginning that that's what we're going to do, instead of having to have those be sentencing alternatives that are difficult to get enough people into. I think when you've got habitual offenders, you know, you have to put them in prison. Unfortunately, that's unavoidable.
What do you feel about, how do you feel about drug laws?
Well, that depends on which drugs and which laws. As the Attorney General, naturally, as long as a law is constitutional, the law is what it is, and you back the state up in doing what they have a right to do under those constitutional laws. And so that's separate from how I feel personally about any of them. I do question whether prosecuting people for the use of marijuana is a good use of state resources, and it's not something that I personally support in terms of spending state resources on doing that. I think, you know, I mean, if we wanted, we could make alcohol illegal, and that didn't work very well in Prohibition. I think having laws against marijuana is somewhat similar to having laws against alcohol. It's just, it's imposing a certain moral view on the populace, and if we really want to look at public health, we should not only focus on the drugs that are really damaging our public health, such as methamphetamine, we should focus most of our resources on ways of dealing with that problem that are actually going to improve public health, mainly treatment. Of course, you have to arrest meth dealers. Of course, you have to arrest meth manufacturers. But by and large, addicts belong in treatment, not in prison.
Any other questions?
How do you feel about sobriety checkpoints in the Fourth Amendment?
To be honest, although all the case law is to the contrary, personally, as a lawyer, having looked at those cases and having looked at what actually happens at sobriety checkpoints, I am baffled by the fact that that is found to be constitutional. I cannot imagine how it comports with the Fourth Amendment to stop citizens at random and accuse them of a crime and demand that they defend themselves and that their persons and vehicles be searched.
Do you believe that case law supports the answer in favor?
Cases that have happened so far have supported the checkpoints. They have found them to be constitutional, and so
What I was asking was, do you believe the case law supports the requirement of citizens to hand over their papers when they're checked, when they're stopped? I know that the case law does support the sobriety checkpoints themselves, but
well, I think that's something that's, with the cases that have been tried so far, basically what the police are doing now has been found to be constitutional. And unfortunately, I don't think that the courts are going to change their minds on that. So I don't think it would be a fruitful area for litigation. I don't think it's something that the Attorney General's office is going to have any particular benefit from getting into at that time. If something changes that makes a difference in that, it may be an issue that we re-examine. But at this point, unfortunately, I think sobriety checkpoints are one of the many things that we have to live with in this country that do not comport with the Fourth Amendment, as much of current police policy and current court interpretation of that policy seems at odds with a plain reading of the Fourth Amendment.